Welcome back to the Legal Weekly Wine. Today, we are talking about the hottest legal topics of the week. And this is really the hottest legal topic of last week and this week. So we are talking about the Supreme Court decisions. And today we are going to address the one regarding Biden's student loan forgiveness program and the one regarding LGBTQ rights. So that's our topic for today, which is really hot this week in talking of, it's everybody's front of mind. I'm Virginia Tehrani. I'm with Tehrani Law LLC, because you never need a lawyer till you do. And I am joined today again by our constitutional law scholar, Dr. John Weil. Welcome back.
Good to be here.
And so everybody knows, if you haven't tuned in with us before, Dr. Weil is a scholar on constitutional law, the Constitution, the amending process, First Amendment freedoms, Fourth Amendment freedoms, and protections, as well as so many other things that I am really pleased that you're able to analyze these two cases, especially today with us, that have just come down.
There's a lot of rhetoric about both cases that, in my judgment, is really far afield.
Interesting.
I actually didn't like the way you formulated one of the issues, but we'll talk about that. You followed the media in saying that one of the cases is primarily about LGBTQ rights, and I don't believe that it is. I mean, it does indirectly deal with that, but I believe it's more a First Amendment case than it is that. And the way you state it often will tell you, probably not in your case, but in many cases will tell you what the person thinks about it.
Right. So, and it's fascinating. And I want to talk about that and have you discuss it more. But that is the way that it is being portrayed, and not to take away from anyone. It does feel like in so much of the country that this was a blow to rights by the LGBTQ community. So it's certainly, the impact is there. Whether the case stated it or not, the impact has certainly been much broader than maybe the specific freedoms discussed.
That's been the perception. I would say that this is one of the cases where I may disagree vehemently with what you say, but you have a right to say it. We're not to say it. We're not to say it. I think in many ways, it's if you consider it as a compelled speech case rather than an LGBT case, then it protects the speech of parties on both sides.
Okay, well, we were going to do
let's do the other one first.
No. We were going to do student loan forgiveness first, but since we're already talking about it, I think it's appropriate to start there. But before we do, because it's the Legal Weekly Wine and it is happy hour, I want people to grab their favorite beverage. And I know for you, it's your trusty bottle of water. For us today, we are going to do a rosé, a beautiful wine. Absolutely gorgeous, as most rosés are. But it's the 4th of July week. It's summer picnic time. I thought we'd do something nice and refreshing. And this one is, and I'm so going to butcher the names, but Babylon Storin, I think is the pronunciation, but it is a rosé, and it's the official rosé of the RHS Chelsea Flower Show of 2021. So nice and flowery, and it is a product of South Africa. So I'm going to, and I keep saying so I apologize for that. We are going to cheers and start with some controversial cases. You ready?
I've got to ask you, did you look up the word storing?
No, I didn't.
Well, you need to look. I don't know. It might be Dutch since it's coming from South Africa, but it would be, is that a family name, or does it mean if you don't know the meaning of this, you're ignorant?
I'm really not wine related. I really have no idea what I'm talking about. So yes, let's look at, I did not even think about it being A family.
I mean, Babylon obviously is a reference to Middle East.
Right.
Used to be one of the Hanging Gardens of Babylon, were one of the 7 wonders of the ancient world.
Oh, so interesting. Okay.
Again, my suspicion is that it might be Dutch or English.
It might be. Let's see. It's a verb, to disturb, to bother, or interfere with.
Huh. What
German?
language?
Oh, there it
German.
is. Hold on. No, it looks like it might be Dutch. I think you might be right. I think it might be Dutch.
Okay, I think I've gotten your whole program all over here.
No, it's so fascinating. I'm glad to know. And it seems to be a verb to intrude, to exasperate, to trouble, to harass, which is absolutely quite fascinating. But yeah, I'm going to have to look that up a little bit more. And
so if you get indigestion after this, you'll know what it really means. You know?
I'm drinking it because these cases are so disturbing. That's what I'm doing. No, that's great. Everybody, you can check out the descriptions in both the audio and video podcasts that we're doing. I always drop a link to the wine so that you can check it out and we can all investigate what the meaning of the name is. But in the meantime, cheers. Oh, that would go well with cheese. That is absolutely a perfect picnic wine. It's almost what I think of that would go with a good Manchego, which I'm butchering the name again. But for those of you listening, you can probably get which cheese I'm talking about. That's how I would.
Is that French?
Wine. I think it's actually Spanish.
Okay. Because,
I think it's the Spanish
if it's French, cheese. I'm going to ask what you did with the money.
No.
When you majored in French.
Manchego, I don't know. We'll move past the names here. Let's talk about this case. Tell us what the actual facts are first so that we're fully understanding.
Okay, now we're doing the
we're going to do the
Creative LLC versus Elenis.
Correct.
I may not be pronouncing right.
The wedding planner case.
So basically, now let me tell you that both of these cases, and frankly, I haven't had time. It's been a very busy week, and I haven't had time to investigate as much as I would like to. But both of these cases have major questions about standing. And this is something that attorneys care a lot more about probably than the typical, person, the non-attorneys. But what is, in theory, at least, U.S. courts do not take hypothetical cases. They do not give, I'm looking for another term.
Oh.
And I'm blanking on it.
And here I am too, and I'm the attorney.
In any event,
they don't give any kind of opinion.
They don't give advisory opinions.
That's what it is.
Right. So to get to the court, you have to establish what's known as standing, which typically means you have to have a genuine case in controversy. You have to have someone who will actually gain or lose, often monetarily, although not necessarily so, but someone who had what we'd say is someone with skin in the game. And this case in Colorado pushes the limits, I would say, of this, because you have, as I understand it, you have a woman who has already some kind of services for weddings. She wants to expand this to, I guess, to the net. She wants to do videos for couples, that she would be paid for, in which they celebrate, where their first date was, how they met, how long they've been together, what their plans are, that sort of thing. And she says that she is concerned and she has some right to, I should say, she has some, in Colorado has a very strict rule against any kind of discrimination against LGBTQ plus individuals. And
so
in fact,
expand protections.
Right. They have a very strong I guess we would say equal protection for all that applies to here. And, this is not the first case that comes out of Colorado. There was previously a case involving something called like Masterpiece Cake. It was a person who did cakes the
wedding cake.
Right. Who was willing to provide cakes or other wedding supplies to all couples, but who was unwilling to decorate cakes that would celebrate gay marriages. And can both these individuals, are professed Christians who say they believe a marriage should be restricted to one man and one woman. And in the previous case, the court actually did side with the cake maker in saying that in adopting this law, that Colorado had actually expressed animus against anyone who did not believe in gay marriage or did not promote gay marriage. And so
it was almost a reverse discrimination, that they were forcing people to comply with others' opinions. So it wasn't necessarily that they were providing equal protection.
Again, the court doesn't usually look into motives. But in this case, in the previous case, it came pretty close. It basically said, this seems to be a law designed to make Christians of this particular persuasion squirm. And it's so obvious that, as long as and so this case is sort of an extension of that. If you can't be forced, if that's the right term here, to put a message on a wedding cake that you disapprove of, are you obligated if a gay couple were to come and say, we want our marriage celebrated on this video? Can you say, no, I don't believe in celebrating that. I don't want to. Now, what's tricky is I think given the laws in place in Colorado, one might suspect that she would run afoul of the law, but she hasn't actually done so. And in fact, to my knowledge, she has not actually even created any videos as yet. And so it becomes something of the critics say the court is leaning over backwards. They're reaching out to create a case in controversy where one doesn't really exist. And there's further controversy, and I don't know the truth of it. She claims that that a gay couple had in fact approached her about doing such a video. The person that she apparently identified says he's not gay and he did not approach her about this. And so this is part of the background, which I think muddles the case a lot.
Yes.
I can understand that if she in fact is planning to do a new business, that she would rather know beforehand whether she is required to do something that she doesn't want to do or not. But is there has she actually done anything to this point where she would win or lose? I think the answer may be no. And so
who was the other party then? Who is the controversial party on the other side that's engaged in this lawsuit?
Well, I think she's okay. Lori Smith is the owner of this Creative 303 Creative LLC. And I'm assuming that Elenis is probably, and I should know this, probably a state defendant, someone who is representing the Colorado law here. I should know that, but I don't remember it right offhand.
So it was actually this wedding planner, so to speak, who sued preemptively.
Well,
the state.
That may be that is the accusation. In other words, the people who think who would rather the court have not interfered are saying that the court leaned over backwards in order to take this case. I don't know enough about the facts to be able to say whether that's correct or not. But you have something of a similar issue, by the way, in the other case that we're going to discuss, the student loan case. There aren't too many people whose student loans were forgiven who are going to be complaining about it.
Right.
And so,
right. They're not saying, did you need to take my money?
Right.
back?
So that's also a case where it has been. Now, what happens in that case is Missouri, if I remember, one of the states who's fighting this, has set up a corporation to handle student loans, and they're saying we're going to lose $44 million because that was the fee we were going to get for handling all these loans. And the court says 44 million, that's real money to most people. And so, that is a case or controversy, but it is interesting. Again, I wish, and I don't think I can do it. I wish I could. I try to, but people are not consistent when it comes to the Supreme Court. Do we favor precedent? Absolutely, if it's a precedent we agree with. What if it's one we disagree with? Well, the Constitution should trump precedent, right? Do we think the court should reach out and take a case that maybe isn't quite yet ripe? Well, if it's a case we think they're going to make the right decision on and it'll go in our favor, of course we do.
But if not,
then we're do we favor an activist court or a restrained court? Well, I have plenty of friends who say the court is too activist. And I say, well, don't I remember you supporting the Warren Court? It was a very activist court. It's hard to be consistent.
Yeah.
And that's one of the things to remember about the court. And here here I'll be a little critical. The court does need to make sure that it is dealing with real cases and controversies, and that it clearly delineates why this is so, why it's not just a hypothetical case. Because if we consider that the court is simply reaching out to do, to particularly, we think justices are increasingly appointed according to litmus tests, even though we say that we don't believe in them, right?
Right.
And if it's perceived that judges have been confirmed and justices have been confirmed because they're promising to do something and then they do it, and they not only do it in a real case, but they bend over backwards to find a case, that does undermine the legitimacy of courts.
Right. No, that's absolutely fascinating. So with this, was there any dissent that said we don't have standing? This isn't ripe for review. We shouldn't be doing it at all.
Well, I think there were questions in the dissent, but most of them focused on the issue. And again, what's so fascinating about this case, and I've chided you a little bit, but I've shouted at my television and constantly having people saying, this is a case about LGBTQ rights. Well, yes, their rights are involved, but it's also, that's the negative spin given the way it went. But the positive spin is this is a case in which the court stood against the principle of compelled speech. If you look at the precedents the court cites, one of them is the West Virginia versus Barnett, the court case that says you cannot compel a student to salute the American flag if it's against their beliefs. Why? Because just as we have a right to speak, we also have a right not to speak or not to affirm something that we disagree with. And the majority, and it's a 6-3 majority, all three Trump appointees are on one side, although, they have three others there. And then you have three justices, Sotomayor, Kagan, and Jackson, who dissent and basically say this is really a case about unfair, it's a case involving interstate commerce. In other words, you have a public business. It's not just family and friends. You want to set up a business. You want to invite people who are getting married to use your services. And then you're saying, but we won't serve you if you're gay. Now, that's what the dissenters say.
And they're saying the interstate commerce part of it is because you're putting your services on the internet.
Right. In other words, the dissenters have a real concern, which is that if people in interstate commerce, and that's how we enforce largely the Equal Protection Clause, if people in interstate commerce say, well, I don't serve redheads, or I don't want to serve African Americans, or, I mean, to take the one that would be the most obvious here, what if someone has, and I don't know that there are any religious groups today, but certainly in the past there were religious groups who believed that racially mixed marriages were unbiblical or unchristian.
Right.
So does this give the right to now I got to make a qualification.
Finish that thought. Okay.
Right. The dissenters are saying this is a case of rank discrimination against LGBTQ. The majority says, and one of the fascinating things, and one of the things that smells a little odd about this case, and you'll know more about this than I do as an attorney, but this is a case of stipulations. There are like 8 to 10 stipulations that frame how the court has to decide this case. Right. And one of the stipulations is that Ms. Smith is willing to serve LGBT couples. What she says she's not willing to do is to compose a message or a video that celebrates something that she believes is immoral.
Oh, interesting.
So it's not that, in my judgment, Justice Sotomayor has overstated in her dissent when she says this is a clear case of discrimination against LGBTQ. The justices in the majority say no. The stipulation says she's quite willing to serve. She simply is unwilling to give a speech, a video on behalf of a group that when she thinks it's something wrong.
Okay.
And according to them, this works both ways. If I'm gay and I'm doing a similar service and somebody comes and says, I want you to do a video in which we say we're getting married because we're heterosexual and that's the only kind of marriage there is, then they would, as I understand it, have the right to say, no, I don't believe that's the only kind of marriage there is. I don't want to do this video. So that's why I gave that quotation earlier, that if you want to put the most positive spin on it, it is, I don't believe in what you say, but you have the right to say it, or in this case, not to say it. Okay. So the court is saying this is a free speech issue. You shouldn't force an African American or any American to, if a Nazi comes to them and says, I want you to celebrate white supremacy. We're getting married in a white supremacist campground, and we want the whole world to know that we're going to have white children. You would be able to say, no, I mean, do if you want to do a video, you do it yourself. I'm not going to do it for you. Okay. So that's how, that's the more, if you want a positive headline, the positive headline is the Supreme Court has protected the First Amendment right against compelled speech. Now, for all,
everyone, for heterosexuals, for the LGBTQ, even for Nazi supremacists, but in the sense that they can do their own.
That's right.
They don't have to do others. That is an interesting take that I have not heard in the media, but I think is a fair analysis of what the court actually decided, as well as these stipulations. I think is a really good point, is that stipulations are things that both parties in a lawsuit agree to.
Yeah, and again,
the things we agree to, these are the facts that we will consent and send up. Right. And if the Supreme Court only has those facts to use, they can't make up other facts. They can't go around that.
So may I read a few of them? There's 1, 2, 3, 4, 5, 6, 7. There are 9 stipulations at the district court level. 1, Ms. Smith is, quote, willing to work with all people regardless of classification such as race, creed, sexual orientation, and gender. She will gladly create custom graphics and websites for clients of any sexual orientation. 2, she will not produce content that, quote, contradicts biblical truth. 3, her belief that marriage is a union between one man and one woman is sincerely held. 4, all the graphic and website design services she provides are expressive, which is, First Amendment limitation. Websites are original customized creations that contribute to the overall message. Again, expressive in nature. Most of the viewers will know that the websites are Miss Smith's and 303 Creative's original artwork, as opposed to, this is a generic thing that you can use. And finally, and this is also of some importance, although, well, I have some reservations about it. To the extent Ms. Smith may not be able to provide certain services to a potential customer, quote, there are numerous companies in the state of Colorado and across the nation who offer custom design web services.
And I think that's what's hard for me. And that's with a lot of these cases coming down, not just LGBTQ cases, is in the end, can't you just use somebody else's services? It's like the post office case is if he doesn't want to work on Sundays, why can't you just find another employee who wants to work on Sundays?
Well, let's put a qualification. We all know about the green books, right?
The what?
Green books.
I don't think everyone does.
Okay. So prior to Brown versus Board of Education, if African Americans wanted to take a trip, they would typically go out and find a green book. And it would say, if you can't get service in any other motel, this motel will house you. Or if you can't find any service stations, here's a service station that will service you. And so one could imagine a situation where prejudice against a certain group was so extensive that they would, in fact, and that's why I'm saying in this case, they're trying to get around that by saying this is not a service that if we don't do it, others can't. But, I would hate for somebody to say, well, yeah, there are half the restaurants in your city that won't serve you, but there are half that will. That wouldn't be very satisfactory to me.
Right. And I guess it goes back to the school segregation as well. You have other schools that you can use, but the quality wasn't there to actually be equal.
That's right. They were separate. They were more separate than they were equal. So, I mean, I understand, both sides here. We see any infringement on liberty as a potential camel's nose in the tent or slippery slope. And I can understand the concern of the LGBTQ or any other community, but I do believe that ultimately it may be a decision that would protect rights on both sides. And what's fascinating about it, I was, as you know, I contribute regularly to this online First Amendment encyclopedia, and I try to get them to give me most of the religion cases because I've done a lot of writing and research in that area. And I thought it was going to be a free exercise case.
One of the freedom of religion cases.
But to my knowledge, I don't think it's certainly not mentioned in the majority, or if it is, it's only in passing. It's considered to be a pure speech, pure expression, pure compel speech case that doesn't have anything to do. I mean, her belief, it does say in the stipulation that her belief is sincere, but
which is not where we get the religious part of it.
Right. But it's not decided on free exercise grounds. It's decided on First Amendment free speech grounds. And I don't know, is productions, would that also be free press?
I mean, the publication.
Yeah, I mean,
that is a good question. Is this business or is it press? And I'm not sure how that ruling would go.
Probably more business than press, but in any event, it's a really fascinating case. Here's what I think people are missing. I'm going to say the same thing now we've already covered it, but on the affirmative action case.
Yes.
It's being portrayed as though, and what Gorsuch writes this decision, am I right?
For the affirmative action?
No, I'm sorry. Right. For the cake case or the
wedding planner case.
The wedding planner case.
I believe that's correct.
Gorsuch, and it's not that long ago, you can look back at dissents usually by Scalia, which come close to being homophobic. That may be a little unfair. But certainly,
I think that's the perception.
Right. I mean, well,
and that's part of the problem.
Well, let's back up a minute. In Scalia's case, he clearly does believe did believe, I think pretty much that traditional marriage, one man, one woman, that's it. And that comes across in the vigor of his dissents. But in this case, Justice Gorsuch, who has written opinions on behalf of LGBT rights, he's not saying he is opposed to gay marriage or that gay marriage is immoral or unbiblical or unchristian. He is, and okay, then let's go. And in the Harvard case, the justices who are opposed to quotas, they're not saying we shouldn't have racial considerations because one race is inferior to the other. They're saying we shouldn't have racial considerations because the Constitution calls for equal protection of the law. They're arguing from really liberal in the good way, not liberal,
more inclusive.
But yes, they're arguing from liberal premises. Now, I understand that one can say, well, we need to use race to overcome race. But Justice Roberts says, well, I think the best way to overcome race is not to use race. They're both legitimate arguments, and they don't prove that they're not, they don't seem to be racist motivated, nor in my judgment, does the case we're talking about now seem to be homophobic. Now it can be, if you have a headline that says Supreme Court rules against LGBT, but it would be like saying, a court rules against, if the court, let's say there's a Christian sect who believe in sacrificing their young, and the court rules against them, and you would say court rules against Christians. Well, no, it's not ruling against Christians. It's ruling against a set of behaviors. And in this case, it's saying we believe all people have the right to express what they want to and not to have to express what they don't want to. And that's how we're ruling.
Yeah. I think the ultimate fear, though, and that's being presented by the dissent, is that it's such a naive view that, yes, everyone should have equal protection. No right should be limited. You should have equality, but there isn't actually equality.
Right.
That
and
it's
that's
almost like a Brown versus Board is we're saying everyone's equal, but we're not. So because we're still not quite equal, isn't it more appropriate to err on the other side to create that equality rather than presume it exists?
Right. And the point that I'm making is more limited. It's that people on both sides are arguing from the same premise that people are created equal, to go back to our July 4th presentation. How do you best implement equality? One group says we need to take race in consideration. The other group says we don't. But, particularly if you view it as you just stated it as what the facts are now, then one could argue that the court is becoming public policy oriented rather than, I mean, legally, the principle that equal protection of the law means no consideration of race, that's a very good general principle, even though maybe in reality, it's sometimes, it's more an aspirational goal. Well, sort of like the Declaration, when the Declaration of Independence is written, all men are created equal. Well, tell that to the slaves outside on your plantation, Mr. Jefferson.
Exactly.
Yeah, they probably didn't feel very equal.
Right. Okay. Wow. Well, I love these thoughts and I appreciate your analysis and especially breaking it down to what the actual facts are and what they're not, so that, opinions on both sides absolutely are legitimate. But getting back to what is and is not said, I think is very important.
It's one of the things that bothers me right now. A lot of things bother me. But, I used to love to read Justice Scalia's decisions. Mm-hmm. And I like to read Justice Ginsburg's decisions.
They're fascinating.
But sometimes there's a little bit, they catch the eye. And of course, if you're writing on dissent, particularly if you're the only dissenter, you can say what you want to, and you don't have to get anybody else to agree with you. So you can state it as strongly as you want. But I think we've gotten intoxicated by this. And I think the dissenting justices in these last 4 cases have just gone overboard. I don't think it's fair to say, this is we're reinstituting race in the United States. You may disagree with the decision. You may think the outcome isn't good, but that's not what these people are saying. And in this case, Sotomayor, as I understand it, as I read it, she basically says this is giving permission to people to discriminate in their businesses, not to serve LGBTQ customers. And the stipulations clearly state that that's not what's happening here, that this person is willing to serve. She's simply unwilling, or maybe simply, I'll not put the simply in there, not to oversent, but she is simply unwilling to do messages that she thinks contradict her own beliefs.
All right. I love it. So on that note, let's then talk about the executive power.
Okay. You get me wound up there too. Okay.
I know, right? So this is exciting stuff. And that's the thing is I love these Junes just like you do. You probably love them more than me. And in terms of the Supreme Court rulings and waiting and seeing what those big cases are, but especially this summer, how many people have been sitting around waiting for this student loan forgiveness program to be reviewed?
40 million of them, or is it 20 million? It's 30. Yeah.
As if it matters, right? It's so many people who are just holding their breath as to whether the forgiveness program will be approved. Now, before we get into that, though, I believe that even without this act, some of it has already been forgiven. Is that correct?
Well, as I understand it, the law has certain provisions. No, I don't think you are. The law has certain provisions that, there are individualized cases of hardship or death or that kind of thing where loans can be forgiven routinely. There are provisions. I think where you're correct is part of the law, the collection has been temporarily suspended.
Okay.
As a result of COVID. And there were a lot of people whose, jobs were in jeopardy or would have been unable to pay during that time. Biden then says, well, I'm going to extend, not only am I going to extend the time or the interest, but we're going to extend the payment. And he did so in a fashion that he forgave more for those who were Pell eligible and those who earn less than $125,000 a year.
Gotcha.
But it basically extended. I mean, it's a $400 billion loan forgiveness. And where I come, Senator Everett Dirksen used to say, a million here, a million there. Pretty soon you're talking about real money. We're talking 400 and some billion dollars of loan forgiveness. And
that
Biden
was projected through this program.
Right. In other words, Biden was willing to give that much loan forgiveness to many borrowers, some pretty much full forgiveness, others, again, depending on their income, depending on their Pell eligibility and whatever less. And essentially the states object. And let's go back here again. There is some question as to how the states establish standing. We talked about earlier, there aren't many people whose loans were forgiven who said, I want to pay the full amount.
Don't do this.
Please don't do this. But ultimately, the court, in what some people think is a fairly slender read, found a way to establish standing by saying, here's a loan organization that Missouri has commissioned that it costs them at least $40 million in profit were they to lose these loans. But here's what I want, and this, I want consistency.
Yeah,
right?
We've been talking about that as be consistent across the board.
So when Donald Trump was president, I thought one of the most outrageous things that he tried to do was, after Congress turned down $5 billion worth, drop in the bucket compared to this, $5 billion, I believe it was $5 billion that he wanted to allocate to build the wall between the United States and Mexico.
Mm-hmm. Right.
He said, well, that's fine. You won't give me the money. You've given me money for defense. This is for our defense. I'm going to spend the money there. I thought that was outrageous because I'm a traditionalist. I believe in separation of powers. And to overemphasize, I believe that the legislature appropriates money and makes laws. The president enforces the laws, and the Supreme Court and other courts interpret the laws.
Which is what is the setup in Articles 1, 2, and 3.
Again, and that's simplified. That's the 2-minute version of the 2-day lecture on separation of powers. But I think there's a real concern when the president begins. Now, it depends on the legislation. There is some legislation where Congress will say, this is going to be the tariff unless X takes place. And in that case, the president can lower or raise the tariff accordingly to respond to other developments. And I think this law that the Trump and the agencies were trying to use, it gave the president some power to modify student loans dependent on certain circumstances.
And this was a specific statute that Congress enacted.
That's right. U.S. Code 2020 USC, and then the long number after that. He can waive or modify. It's called the HEROES Act, HEROES. Authorizes the secretary, quote, to waive or modify any statutory or regulatory provision applicable to the Student Financial Assistance Program under Title IV of the Education Act as the secretary deems necessary in connection with a war or other military or national emergency. So does that cover what Biden did when he suspended loan payments during COVID? I think one could reasonably say yes.
Based on a national emergency.
There was, it wasn't a war, but a million people died. That's more than died in most U.S. wars. Under those circumstances, discombobulation, all the things that occurred, I think that was reasonable. Is it reasonable? Now, do understand that Congress has subsequently, in the face of this, they have discussed, should we forgive student loans? And some members of Congress said yes, and others said no, but they did not adopt specific authorizing resolution for giving the loans.
And what this ultimately comes down to then is, I believe the court is saying, and please say if I'm wrong, but I believe the court is saying not that we can't forgive student loans, but the executive is not the place to do it.
That's right.
It's Congress.
That's right. And that being said, and you need to know, this is, if there is a consistent theme of the Roberts Court, particularly in the last 2 or 3 years, it is, we are tired of agencies, whether it's the EPA or, education department or whatever it is, we are tired of them making policies that goes so far beyond the original legislation that it's hardly recognizable. We're going to leave it to Congress. Now, that being said, in my humble judgment, we have as dysfunctional a Congress as we have ever had. But
they do not seem to be able to come together.
They don't seem to have their act together, in part because the country is so closely divided ideologically.
Right.
And when that happens, it means existing laws are unlikely to be rewritten, even sometimes in the face of dire emergencies, because, and in part, and this is the sad thing, in part because members of Congress, even if they see something that they think should be done, they don't want it being done during the administration of the party opposite there. They don't want the other party to get credit for it. So in some ways, it's sort of sad that at the time when the court is saying Congress needs to step up to the plate, that it doesn't seem to be doing so. But that's my interpretation of the case. They're not right. Congress has the power to appropriate money or not to appropriate money, to forgive debts if they want to, but the court said, the majority says, this law does not give adequate authorization for what the president and the education department are trying to do.
Right, because it's not, I mean, you were reading the law off, and it seems fairly clear upon reading it that it's limited to national emergencies and not just regular basis.
There's a difference between modifying a law and abrogating a law. And as you know, one of my favorite topics of study is the constitutional amending process.
Yes.
And one of the things that I'm particularly interested in are those occasions where a Supreme Court justice will object and say, we have the power to interpret the law, but that's different from the power to amending the Constitution.
Right.
Equal. Well, this is a little bit dated now, but we believe in equal rights for women, but you haven't adopted the Equal Rights Amendment. Probably not the best example, but just because it seems like, it's hard. Well, it's hard to be against loan forgiveness, but I can actually make a pretty good argument as to why loan forgiveness is unfair. And the argument is this. How many people maybe didn't go to college at all because they couldn't afford it?
Right.
Or in making, and of course I come from a state university, so I have a dog in this fight. But how many people who could have gone to maybe a community college for free for 2 years and maybe gone to a state college where they could have gotten a scholarship, where they would have had in-state tuition, if they chose instead to go to an Ivy League university, is this fair to the working, the children of the working poor maybe, or lower middle class who didn't have these opportunities, to say, we're going to use tax monies that you thought you were going to get back, and we're going to give it to these graduates of school, who spend a lot of money on their education.
Right. And it's hard for me too, in that same line, because I mean, how many years ago did I go to law school or to undergrad? And, the question is, what about you? I mean, you went to school how long ago, and would your loans be forgiven? Well, if mine would be forgiven, why can't yours be forgiven? And It's a question of how far back would we go? How unfair is it to the current party or the former party? And for me, as part of my decision, as you know, I mean, I went to great schools. I went to Middle Tennessee State University, where you are, attended the Honors College, graduated from there. Went to William and Mary. These are no, small schools with poor averages or rankings. But part of the reason that I chose them, and I'm so thrilled that I did, but part of it was a calculation of all of the schools that I've applied to, which ones will I get the most value for my dollar?
Right.
And I could have gone to many other private schools. I got accepted to other private schools.
Absolutely. But they gave you good scholarships, and they were still twice the cost of coming here.
Exactly. Yes. I did get scholarships. And how unfortunate then would it be to say, look, because I fought for all those scholarships, because I got scholarships to both of the colleges that I went to for undergrad and law school. Well, if I had to fight to get there, why did I even try to get a scholarship when I could have just gone and paid for it all, not worked as hard, not done the fellowships that I did, so that I could have just taken out a loan and been forgiven for it?
Well, and part of this does go to, and here's where people may get caught short. A person 2 or 3 years ago, when this was put into place, going to college might get in their mind, well, if they were forgave for this, maybe they'll forgive me down the line. And so it does call into question sort of the whole student loan idea for the future.
Yeah. All right. So that's great thoughts on it. I really appreciate you adding your thoughts and talking us through these cases, because I think both of them are fairly well misunderstood.
And again, watch the headlines. You see a headline, the Supreme Court is against college students. No, that's not what it's, now that, and I'm not making it, I mean, maybe I have sort of tipped my hand here, but, under certain circumstances, I would be for loan forgiveness.
Sure.
But I think that if it occurs, we have a representative democracy. And if you look at the Constitution, the first 3 articles, legislative, executive, and judicial, and they're that way for a reason, because they thought the legislative branch was going to be the most representative of the people.
Right. They didn't want a monarchy. They didn't want a king.
That's what the Declaration of Independence is all about. We're not kowtowing to a king or to a president, whether his name is Trump or Biden or any other.
Right.
But to be fair about it.
Okay. Thank you so much for reviewing these Supreme Court decisions. And what we will do, we're going to wrap up the weekly wine for today. I'm not sure where we're headed next for next week after all of these flurry of Supreme Court decisions, but we will absolutely figure out what the hottest legal topic is of the week. I'm Virginia Tehrani. I'm with Tehrani Law LLC, and this is Dr. John Weil from Middle Tennessee State University. And we will catch you on the next Legal Weekly Wine.